Court rise.
Well, could I now turn to issue 1, which is picked up in our printed case at paragraphs 9 to 43. Well, the text of the ministerial directive is in the statement of facts and issues, but conveniently, I hope, set out in paragraph 13 of our printed case. And the Lordship will see that it's prefaced by a series of recitals, and the recitals we submit are important in understanding the directive and putting it into its context. So could I take the recitals as read and not go through them? My Lord, the 4 steps in the argument are essentially as follows. Firstly, first step, the officer's functions are subject to the exercise of the Section 6 power. The office is obliged to give effect to such directions. The second step is that the direction in 2002 fell within Section 6 and was a direction of a general nature as to policy. Thirdly, that exercise of ministerial power was not otherwise bad in law, which is Padfield, irrationality, all the usual candidates in the public law case. And the final step is that the decisions, the determinations of the office, particularly paragraphs 2.6 and 2.8 of the May 2002 determination, were issued contrary to that direction. So those are the 4 steps.
Isn't that therefore issue 3 as well?
It is more. That is, they're the 4 steps in the argument, but the final point is issue 3. And when we get to that, my Lord, I hope I can take that fairly quickly, because you will have noticed, my Lord, that the office itself takes no position on.
Well, I did notice that. I know.
Well, my Lord, that we will be inviting the office to come off the fence on that issue, as it is its own determination, and we say it's a clear contravention of the direction and was intended so to be. Indeed,
they're taking legal advice in order to build as they thought to do it.
Exactly. But that's pursued by Cable and Wireless, so I'll have to address it. But that's the 4th step in the reasoning. But, my Lord, could I then...
To what extent are these points of future importance, or are they, as opposed to mere historical interest?
My Lord, they are they're only of historical importance in relation to the effect of 2.6 and 2.8, but that has a significant monetary value. Lord, I'll come back to this if I have to. The effect, I hope I've got these figures right, the effect of the decision at first instance was that Cable and Wireless had to pay over to Digicel somewhere in the region of $2 million US, something like that. When it came to the Court of Appeal, which was 4 years later, and there was a reaccounting, by that time, with the interest rates in Jamaica, which have been described to me with tears in his eyes by my learned junior, that had reached somewhere in the region of $3 million US, and by now, if there's a reaccounting, it's somewhere in the region of $6 million US. So it's more of, it isn't just historical value. But the continuing importance is in relation to the ability of the minister to exercise policy control through Section 6. Lord, in a few moments, I'll show your Lordships, with your Lordship's permission, a direction issued in 2004 during the course of the proceedings, but not in the papers. And there has now been a change of administration in Jamaica, so the same minister is not there, but it is not unknown for ministers to return. So the issue may arise again. But Lord, could I deal with what is perhaps of universal importance, is what is meant by a direction of general nature as to policy. And we address this at paragraphs 19 to 21 of our printed case. And could I just pick out one or two sentences of those printed submissions, taking the rest as read? In paragraph 19, in the middle of the paragraph, we say this: a direction of a general nature as to the policy does not cease to be general merely because it refers, as here, to a particular aspect, the setting of rates, tariffs or price caps on interconnection or retail charges, of a particular sector of the telecommunications market, the mobile or cellular market. It is inevitable that policy in an area such as telecommunications, if it is to be of any effect in promoting and achieving the policy objectives, that should be affect, is bound to have some degree of specificity. I'll get that right one day. Otherwise, what was intended to be a direction would descend into broadly formulated and worthless generalizations. Part 2 of the direction, the OUR is to facilitate competition and investment for the new mobile carriers in Jamaica, was also ignored by the office when issuing its 2002 determination that was similarly of a general nature as to policy. And so if I could... I
mean, you might have said instead of similarly, yet more obviously.
Yes, similarly, yet more obviously. Lord, over the page, we pick up submissions made on behalf of the Minister and adopt them as our own. The reference, my Lord, to the pages, the record, volume 3, you need not return to, is those are the first instance submissions. Volume 5, tab 46, page 2006, are the submissions made on behalf of the Minister adopted by Digicel to the Court of Appeal. Well, if I could just read that out, I won't take you to the full submission. It's a general nature relating to policy. One may conclude after an examination of direction that directs the OUR to allow free competition by not intervening in the market to set rates, tariffs or price caps. In other words, it seeks to instruct the OUR to adopt a more market-oriented approach as opposed to a more interventionist regulatory approach.
You could take out the more in both cases, couldn't you?
Yes, Lord. Yes, in the terms of the first direction. Yes. It does not speak to a particular competitor or a particular segment of the competitors in the industry. It does not seek to set a particular rate. The direction lacks the word I can't pronounce. It speaks to the general policy approach that ought to be adopted in respect to interconnection. The fact that the desired outcome is articulated in the direction does not make it invalid. Like all policy decisions, the direction will affect specific acts. The fact that it does so does not detract from it being in the nature of a general policy. Lord, 21 I needn't deal with, trying to grapple with what is meant by the word policy, but interesting in the passage underlined at the New Zealand Court of Appeal in the North Shore City Council case, and for your note, that's volume 1, tab 3, made the, that's obvious but helpful statement: counsel for the defendants is on unsound ground in suggesting that in New Zealand speech or parliamentary drafting or etymology policy cannot include something highly specific. But here, my Lord, we have the combination of words, the direction of general nature as to policy. So
I remember policy once being described as an advance indication of how a discretion will be exercised.
That would do, my Lord. That's not far off what we're saying. We're saying that when it comes to an exercise of discretion, Mr. Regulator, I am directing you that my general policy steer is that you will not intervene to exercise that discretion in this particular sector of the market at present, for sound policy reasons, which I consider to be in the public interest. And one can grapple with and reformulate that direction over and over again in different ways. You can turn it into a positive, a negative, however one does it. We still say it's in section 6. And my Lord, if I go into paragraph 23, and then I'll leave these first paragraphs of the submission. Lord, in paragraph 23, we're dealing with the reasoning of the Court of Appeal, and those are internal pages to the decision of the Court of Appeal, and it's the record, volume 5, page 51. Lord, you'll see in paragraph 22 that I'm identifying there the powers relied on by the President in his judgment, which it says the direction interferes with to the extent of being unlawful. And then it's the ones we've been looking at, 4.4 of the Office of Utilities Act, 46.2, 29.4 and 33, 1 and 2 of the main Act. And 23, if I could go to the last sentence, with great respect the learned Judge of Appeal, the remaining members of the bench, these conclusions disregard the clear wording of section 6. All functions of the AUR are expressly made subject to the exercise of ministerial power under section 6. And 24, what the direction indicates is that the policy of the government is that price caps are not to be imposed on the cellular mobile market, but the market is to find its levels by the effect of competition. And, my Lord, you'll see over the next page, and I won't now go through them again, but these are our submissions, which I don't read out, on the main sections identified by the Court of Appeal as being offended by the ministerial direction. Well, I will come to the evidence from the Minister in a few moments. But not...
At some stage,
Yes.
I would be grateful for an explanation as to how competition works in a situation where the mobile provider sets the price, but it's paid for ultimately by the customer who phones a particular person who has a particular mobile phone contract.
Let me see if I can just grapple with that immediately, because it's something I'm not finding easy to grapple with as well. It's part of the calling party pays system in Jamaica with its own idiosyncratic wrinkle. What's happening is that the calling party pay route is going from a fixed line holder through the fixed line to Digicel's mobile phone. The price the customer is paying is fixed by Digicel. And remember that this is on the network of a monopoly fixed line operator. The OUR fixed a cap for that price, the retail price of, let's say, $12. That means that Digicel can say to Cable and Wireless, the price for your customer to call me, calling party pays, is not going to be 12, it's going to be 10. And I will collect my part of that, you keep your retention and your provision for bad debt. That's what I will get. Another operator will see that happening, will see the prices, and say, no, I will say it's 7 or 11, whatever. So what you've got is market forces operating from the mobile networks who are setting the price, even though it's Cable and Wireless's customer that is being billed by Cable and Wireless, and then there's an accounting mechanism.
That doesn't
really
address my difficulty. I have a landline,
yes.
and I have 4 daughters. I have actually got 3 daughters. Right? 3 will do.
I cry for your
And
worship.
each of those has a mobile phone.
Yes.
And each one has a contract with a different mobile phone company. Now, I want to talk to daughter A, and I'm stuck with the fact that daughter A's got a rather expensive contract.
Exactly.
I haven't got any choice if I want to talk to daughter A. And so the only way competition can work, it seems to me, is if I find out that it's much cheaper talking to daughter B than daughter A, then I say to daughter A, why on earth don't you change to a cheaper company? Is that right?
Yes.
Is that the way it works?
Yes.
It's a pretty oblique way of competition working, isn't it?
No more. That's market forces. With 3 daughters, you need all the help you can get. That's
If the daughters had the choice, if they were paying, I can see readily market forces would make daughter A say, well, daughter B is getting this much more cheaply than I am, and switch to the provider of daughter
sorry,
B.
Lord, you have complicated the analysis by introducing a lack of independence.
It's even more difficult to see how competition works if the 3 are not even in communication with each other.
Could I read this sentence and see if this helps? Fixed to mobile charges, which are fixed by the terminating mobile carrier, although levied at the fixed line.
Yes.
Fixed to mobile charges appear to have become a vehicle for mobile service competition that benefits the public. And then
That's your thesis.
No, that's all you.
Yeah.
That's the OUR. That's what the
But
OUR.
how?
That's what the OUR said.
Yes.
But your Lordship has already touched on how it happens. Daughter A is spoken to by father X, who says to daughter A, I'm not very happy by paying your bills, daughter A, when I can talk to daughter B on Clara or Centennial or other, when it's cheaper. And deals will be done, offered on the internet, offered on television, offered in the marketplace. And Cable and Wireless also has its own mobile network, presently called Lime, I think, but it used to be called B Mobile. And so it has its own body which is advertised out there. So it is competing with Digicel. So it will be trying to offer to daughter C a better deal. So eventually father X says to A, I'm no longer funding this, you're going to move off to Digicel or B Mobile, I think it was called. Yeah. But the importance is that this process furthers competition. And if I give you the reference from the OUR consultation document, the importance is the date. It's December 2001. So we're in the middle of this initial process of liberalisation. And it's the PC, the Privy Council record, Volume 1, page 155. Fixed to mobile charges appear to have become a vehicle for mobile service competition that benefits the public.
This is after agreement.
So we've already got our agreement in place, moving forward, and then comes what looks like bad news on the horizon in terms of damaging competition, which is thriving and benefiting everybody, and the Minister steps in to exercise his power. Lord, I haven't fully answered. I can see by I recognise the expression.
Well, I follow your answers as far as it goes.
Right.
And I can quite see that the more they're allowed to charge, maybe the more competitors there will be.
It isn't just the more, it's the ability to charge less, but ensuring that the new mobile operator that is new into the market gets an income stream to it, which it can control in terms of cutting its margins and reducing its ability to make a profit. But what's happening here in 2 ways. In 2.6, there's a potential to reduce the amount that flows back into its coffers, because they're now fixed at 6.83 cents, in $6.83.
But isn't what the Minister's really saying is, I don't actually want market forces working at the moment, because Cable and Wireless have got a market advantage, and if I leave market forces, the others will simply be squeezed out. I want a policy which will let the others come in.
Yeah.
Maybe later on there'll be scope for...
No, Lord, I think he's saying, we look at his evidence as well in a moment, he's saying that I want there to be competition, and I want there to be competition that survives. And I don't want the dominant carrier to kill the competition, but I do want the new mobile operators to have the opportunity to make sufficient return so that they who are here now can continue to invest, and those who are about to enter the country will still enter. So it is market forces, but it's saying regulatory soft touch. That's in summary what he's saying in paragraph 1, with a policy objective. Well, can I come back to the ministerial evidence in the moment. Just to correct a reference, in our printed case at paragraph 24, right at the end of the 29.4 part, which should be page 11 on my copy.
1141.
On paragraph 24 of our printed case.
Yes, yes. What's the wrong reference?
There are 3 references or 4 references to the evidence of the minister, and it should say record volume 3, and it says for no reason tab 23 when it should be tab 18. That's all.
It says tab 17.
The next one down, my lord.
That's page 11 is on.
The page 11 on my copy. Page 11, 3 lines up.
Oh, I see.
Well, there's the
It's just,
second reference.
I'll be taking you through it later. I don't want you to search for the wrong reference.
Tab 18, okay.
And Lord, at paragraph 29, again, without going through it in detail, the minister's affidavit shows a very serious attempt was made at all times to balance the welfare and interests of the consumer with the promotion of competition and continued investment.
Paragraph 29, page 13.
Lord, before I go to the minister's evidence, which I'd like to spend a few minutes on, last week we were looking for examples of ministerial directions that had been published in the Gazette, because that's one of issue 5 of, as I call it, the supplementary issue, that every direction should be published. So we looked to see if there were others that had been published. And what we found were directions that, surprise, surprise, hadn't been published. But we did find one direction which may be of interest to the court in looking at how Section 6 powers can be used without apparent complaint. And, my Lord, we have a little clip of, let me explain. There are 3 decisions by the OUR, all in 2004, so that's between the 2 hearings. This would be new evidence, Ladden, Marshall, etc. principles would apply. All I'm relying on it for is to show your Lordship an example of a ministerial directive. What we've been doing backstage is drafting our own alternatives to show how the power could operate, and we had produced a sample direction based on child protection services, a classic policy point. And we thought you might be more assisted by seeing an actual other ministerial directive. So there's now no objection from a learned friends, which your Lordship see.
Yes, that's right.
Could you hand up, there's a binder which should say a decision of the Office of Utilities Regulations in 2004. Well, let me explain what's in and then explain my limited reference to it. There are here 3 decisions on settlement rates. 23rd of January 2004, 7th of May 2004, 9th of June 2004. And all I wanted to show you was the ministerial directive itself, not the response by the office. And the directive is on the first page of the first decision. The Minister of Commerce, Science and Technology, which is still the same minister, in his own recognition of the crisis in the market, and pursuant to the powers vested in him by Section 6 of the Act, issued 2 directions to the office. And the first one states, undertake and implement such acts of regulatory intervention in the mobile cellular market, howsoever defined, as will stimulate sustainable, effective competition among carriers and service providers. So that's one part of it. In the exercise of its powers under Section 4.1f, require such information from licensees as will enable the Minister to assess the effectiveness of the policy directive. And 3, having specific regard to the directive at paragraph 1 above, in the exercise of its powers under sections 29, 33 and 33, there must be a missing line.
33.1 and 33.2.
Yes, that's the reference to those sections. The second directive, with immediate effect, undertake and implement such acts of regulatory intervention in the market for international voice services as will establish an appropriate international settlement rate at which licensed operators shall provide such services while continuing to maintain sustainable, effective competition amongst carriers and service providers. It's specifically intended that any ruling or directive to licensees issued by the regulator pursuant to this ministerial directive shall be immediately binding on such licensees pursuant to the terms and conditions of their licenses, and again, in exercise of its powers, under 4 when it requires such information. So that's a combination of positive, specific in relation to specific powers, but we thought it might be helpful if your Lordship saw that example. Our own rewrite of a sample direction on child protection services is very much simpler. And could I just hand that up to your Lordships to save me reading it out? Sorry, you pass those that way. Well, it's a very brief example, and one can come up with, in the end, hundreds of these things, but this just seemed a good example that took it away from price and caps and that kind of area. Whereas the welfare and protection of children is a public policy or public priority, whereas the government wishes to encourage and support the activities of organisations dedicated to the provision of child protection services, whereas children are likely to avail of such services using fixed or mobile telecommunications services, whereas they are more likely to access child protection services if they are free of charge and if their use does not generate a retail billing record, whereas carriers should, in line with the retail billing regime to be mandated, and in order to avoid disputes concerning charging mechanisms, absorb their own costs in connection with the provision of interconnection to such services. So those are recitals not dissimilar to the child action line in the UK. Accordingly, the OUR is hereby directed in accordance with Section 6, 1, to reserve the number range for child protection services, shall only be allocated by the OUR to carriers, adopt pursuant to Section 46 a price cap, prohibiting the imposition of any charge, price or tariff on a retail customer for a call to child protection on an eligible organisation, etc., refuse or refrain from considering, approving or determining pursuant to any of the functions, powers or duties, any charge, price or tariff for interconnection between carriers in respect of calls to a child protection service number, work with carriers to draw up, propose and implement a voluntary code of practice which we then set up. Well, it's the product of a committee, but at least it gives you another example of how these powers could be drawn up.
Well,
generally.
they could also a good example of attack that might be made on them. I mean, this one might just as well say, have a special dedicated number for children for which you make no charge. That would be the policy.
Yes.
But to go on to say, reserve the number, range 800, 1234, etc., might produce the response, well, that's absolutely absurd. That's very well established as the number you phone if you want the fire brigade.
Well, it would be a different number.
Objection.
But that would be an objection then on rationality, not on vires.
Well, it'd be much too specific. That's none
Well,
of your business.
that's what the reason for this one is to try, and the one we've handed up from 2004, is to assist you in trying to draw some lines exactly for that purpose. And whether that's the right or the wrong side of the line is what those who have to live in this regime want to hear. Well, that's say, just the example. Could I then turn briefly to what the Minister said? The importance of what the Minister said is that his account was not contradicted. It post-dated the accounts given by the two witnesses from the office, and he rejected and denied some allegations made against him. But just as importantly, it would appear that the Court of Appeal has seriously misunderstood his evidence. Could I just show you one example and do this chronologically? Well, volume 3 is where we will find his affidavit, but I wanted first to show you a letter. It's part of the exhibit to Mr. Maurice Charles, so it's tab 18, my lord. This is explained in the Minister's affidavit, but I just wanted to show you what he was writing. This is a letter at page 1301. And put it in its context, my Lord, you'll see it's written personally by the Minister to the Deputy Director General. And the reference to it in his affidavit is paragraph 25, which is at page 1241 of the same bundle. And he's writing this letter, and I quote from his paragraph 25, after being informed of the objections voiced by the OUR. I'm disappointed that the OUR seems to be unaware of the relationship between policy and regulations. Regulations are the detailed implementation of policy. Therefore, all subject areas of regulations are subject areas of policy. The two are inextricably bound. Lord, he then goes through, and I, of course, won't read this all out to your Lordship. On page 1302, he deals with sections 29 and 30, and he says at the top of the page, as you are aware, section 6 of the Act empowers me to give directions of a general nature, etc. Therefore, a policy direction must be in relation to an area the OUR has a statutory function, and it cannot be in an area where the OUR does not have a function. The policy direction is in keeping with the objects of the Act and will promote fair and open competition in the provision of telecommunication services. The policy direction seeks to allow the market to determine prices in a competitive environment, as well as emphasise the important role that the OUR plays in facilitating new investment in the telecommunications industry. It is interesting that you should mention that the direction contradicts section 29 of the Act, which speaks to the OUR making objections to interconnection in the prescribed manner. As it is the Minister who determines the prescribed manner, this very provision demonstrates that interconnection policy and regulation are intertwined. To date, I have not prescribed a manner for objection, nor has the OUR raised with me its desire or intention to object to any internet connection agreement. Then he deals with section 23 and says it's irrelevant. Then he deals with the policy direction and says just below line 30, the policy direction does not prohibit the OUR from assessing interconnection agreements, nor does it limit the OUR from making a determination of the terms and conditions. The direction goes to one area only, charges, and states that the OUR should allow the market to determine this. And Lord, then the next two paragraphs is of some concern to me that the OUR appears to be objecting to operating in a framework transitioning to full liberalisation, as is contemplated by the Act and Jamaica's telecommunication policy. The OUR is not meant to be a rate setter in a competitive market, and the direction merely underscores this. Let me make it abundantly clear that the government seeks to promote competition in the telecommunications market. Competition has proven successful, as it has allowed Jamaica to have an unprecedented growth in the mobile telecommunications market. Let's pause with that important sentence and invite your Lordships to look at the Court of Appeal's analysis of that paragraph. It's in tab 51 of volume 5. If you keep that document open, so it's tab 51. The Minister is clearly explaining how important competition has been in the public interest in allowing Jamaica to have unprecedented growth in the mobile telecommunications market. In the judgment, the learned President at page 2207, this is page 51, internal page, when he is dealing with complaints about the OUR, but he says this, third paragraph, line 10, regulatory control, this is a judge speaking. Regulatory control is the sine qua non of the free market system operating in the telecommunications industry, even within the concept that market forces should be allowed to predominate. The OUR Act created the regulated body, the OUR, and gave it the power to regulate the said industry with specific statutory functions since March 2000. The Minister himself recognised the successful effect of OUR's regulatory activities when in his letter dated the 15th of April, he admitted competition has proven successful as it has allowed Jamaica to have unprecedented growth in the mobile telecommunications offer. So what the learned judge is saying when he's pulling all of his thoughts together on this judgment is that the minister has recognised the successful effect of regulatory activities and points to the very letter where the minister is saying, no, it's competition that has produced the benefit that he is attempting to preserve. Could I just complete the process of correspondence and then show you the affidavit and move to the submissions? In going back to volume 3, my lord, in the same bundle, tab 19, at page 1308, is a letter written by the office which explains, on the basis of legal opinions it has received, why it is reluctant to comply with the direction. And you will see below 20, we have two fundamental problems with the direction, namely the statement that the heart of competition is allowing competitors to have the freedom to charge the prices they wish, and the market determining the viability of competitors. We do not believe that this statement is unreservedly correct. So that's engaging a debate with the minister's reasoning. With the greatest of respect to the office, it was the minister who was stating policy. The direction that the OUR is not to intervene in the mobile market by setting rates, etc., we see this direction as being irreconcilable with our functions as stipulated in 29.4 and 31. And that is then explained at page 1310. And this is their understanding with the subheading direction not to intervene by setting rates is that it's incompatible with 29.4, which I've shown you, Lordship. And over the top of the page, I know that it is the opinion of some distinguished jurists that a particular direction is not specific, but falls in the compass of directions of a general nature. The greatest respect, even if their interpretation is correct in the strictly legal sense, the direction which states that the OUR shall not intervene in a specific instance will be understood by us, and I believe by all other stakeholders, as an overriding instruction and not as a guideline of a general nature as to policy. And then on the final page, there's reference to...
Well, you don't recognise that contract?
No. Lord, I'm showing you...
Well, you might say quite right, but that's what the minister's allowed to do.
Yeah.
Yes, and it isn't a guideline,
Yes.
it's a direction to which you must give effect. And indeed, when I won't come you with the various opinions of some distinguished jurists, there's quite a big misunderstanding of the difference between a power and a duty. On the final page of the letter, page 1312, Mr. Hay, the Director General, deals with communication of government policy and says in the middle paragraph that there should be more openness. I think, therefore, that the ministerial direction should have been made public, perhaps through the Gazette, at the same time as it was communicated to me, the public would then understand. The reply, and if you could keep, again, if you don't mind, my Lord, this bundle open for a second, the reply is short in volume 2, tab 10, at 876. Page 876, Lord, is an exhibit to the affidavit of Mr. Winston Hay, Director General, and it's the reply to the letter I've just shown you, Lordship. Well, Lord, it says July the 30th, 2002, at 1, but it's clearly 2002. See the stamp in the middle of the page. He refers to that letter, and he makes it clear in his letter, in the second paragraph, the third paragraph, given that Digicel only commenced its operation in April 2001 and Centennial in December 2001, the Jamaican mobile market is obviously embryonic An intervention at this time by international standards is premature, especially with full competition still ahead in 2003. The policy direction I have given goes to the heart of competition. People have a right to choose. If one provider's tariffs are too high, people can either change providers or choose not to make certain calls. The Jamaican mobile market is still too much in its infancy to suggest that callers are wedded to one particular carrier or that fixed line providers should be given preferential treatment over mobile providers, when in many rural areas in Jamaica a mobile phone is the only phone many poor Jamaicans have access to. In any event, as you are aware, nothing in the policy direction prohibits the Fair Trading Commission, the competition regulator, from intervening if they consider the behaviour of any telecommunications provider to be anti-competitive or an abuse of a dominant position. Indeed, the examples used by you to support your position, intervention was done not only in the mature market, this is in the UK, but also after a determination by the competition arm of the regulator. Then over the page, my Lord, he encourages a review in the light of the policy direction. So it would be useful to review of the policy direction. So he's contemplating a limited shelf life, conducted a study on the Jamaican mobile market, obtaining a demographic of users and their calling patterns, and substantiated its belief that the government should abandon its policy on technological neutrality in preference for a policy which favours one technology over another. The minister's getting a little tetchy by now. But by the end of the letter, he says, these policy directions are always confidential and privileged matters, and there's no justification for publication. It's paramount is the implementation. Well, so that's the correspondence that was before the Court of Appeal and the first instance judge. Could I then quickly turn to the minister's affidavit? Well, that's volume 3 at tab 17. Well, this, as I pointed out earlier, my Lord, at paragraph 2, this is a response to affidavits of Mr. Hay and Mr. Courtney Jackson. And I see that the submissions made to your lordships by the respondents rely still on the affidavits of Winston Hay and Courtney Jackson, even though there are denials in this witness statement affidavit of the allegations there made. But here, lordships will see, and I won't go through it in detail, but at paragraph 8, you will see on page 1238 that the minister is picking up a specific allegation made by Mr. Hay in his affidavit, and the cross-reference, my Lord, is volume 2, tab 10, page 600. Volume 2, tab 10, page 600. I deny that I've sought to usurp or encroach on the duties and responsibilities of the applicant. I've always been cognizant of the important role that the applicant as a regulatory agency plays in the growth and development of this burgeoning sector. I've never sought to threaten the independence of the office or regard it as a department of the ministry. I've not involved myself in the operational level of the OUR, but restrict my interfacing solely to matters relating to policy. And that's repeated in 9 and onwards. Could I pick it up over the page, my Lord, at 13? I needn't take you to these, but the documents mentioned and referred to in paragraph 7 of the affidavit of Mr. Hay, allegedly giving instructions to OUR staff directly and without informing the management of the OUR, are incorrectly portrayed. And he then deals with that allegation. And then in 15, he deals with the need to establish an independent regulatory framework, and it was he who recommended and piloted the amendment to the 95 Act. Well, that's the name of the Act which we'll find to show the amendments. Between organisations there will be disagreements because of difference of opinion. This is not unique. I acknowledge that there's been some tension. And then this. One reason has been the conflicting approaches to regulation and policy goals in competition law. Mr. Hay's views appears to be that regulation should not consider policy goals such as liberalisation. I do not agree. In my view, independence does not equal isolation. Then in 18, he expands on that, and also in 19, Against the backdrop of the current economic downturn worldwide and the traditional areas of investment for Jamaica, the liberalisation of telecommunications sector has so far proven successful and has been a source of immense investment in Jamaica and considered to be one of the engines of economic growth. And then 20, and this is really 20 to the end is key. Therefore, it is critical that there is a balance between the development of policy goals and the responsibilities of the regulatory agency. He then refers to the set up a talking shop, for want of a better word, and at the end of that paragraph, they meet regularly and report their deliberate recommendations to me. I'm also concerned for the welfare of the consumer, and so I work very closely with the Consumer Affairs Commission. And over the page, I refer to, these are specific paragraphs of the affidavit of Mr. Hay, and I deny that I told Mr. Hay that there was an agreement with Digicel and Cable and Wireless to retain the existing fixed to mobile rates for a further period of 3 years. I also deny that the ministerial direction was issued to prevent the revision of rates in response to pressure from Digicel. And then this. Therefore, I was interested in maintaining the existing climate, which had benefited all the players and increased competition. It was my view that the attractiveness of a fourth licence to a potential bidder would be significantly diminished if an interventionist regulatory policy were adopted, and therefore it's preferable if prices were determined by the natural interplay of market forces. Further, an interventionist regulatory policy may also be a destabilising factor in the market and may directly and significantly affect bidders' projections. Consequently, I met with all the stakeholders involved in the industry to discuss charges with a view to determining the nature of the competition policy to be adopted that best suited the economic climate in Jamaica. And bear in mind the fact that the OUR did not and has not declared any public voice carrier to be dominant, and that the number of mobile lines exceeded the number of fixed lines. Further to those consultations, and after careful considerations as to the most suitable policy to adopt at this juncture, the ministerial direction was issued in order to ensure the protection and promotion of the interests of the consumer, promotion of fair and open competition, and to encourage sustainable investments in relation to interconnection charges and the telecommunications sector generally. There's then reference to a letter that I've taken you to, my Lord. At 27, he refers again specifically to the affidavit of Mr. Hay, that one ought not, without more, compare the regulatory styles adopted in the various regions of the world. One has to examine the unique markets and the indigenous problems that the regulator would seek to address. First, competition in Jamaica mobile cellular market exists for a little over 1 year, so it's a relatively immature market. In the UK, competition has existed for a long time. Then there's reference to the band of prices, and then 28. In developing general policies, and specifically for the ministerial direction, I relied on my own experience, examined the literature and practice from other jurisdictions such as New Zealand, Australia, Canada, and the UK, and fashioned it within the context of Jamaica so as to achieve a best practices situation. Well, that was the evidence before the first instance judge, who found the ministerial direction unobjectionable. And this is, of course, the same information before the Court of Appeal. We say, Lord, that that does give a pretty clear explanation that this is a minister engaging with general policy, and that is what he was seeking to encapsulate in his direction. Well, could I then, if not too fast, deal with the meaning of guidance? And this will take, I hope, only a few minutes. The OUR relies on, also perhaps Cable and Wireless as well, but the OUR relies on the Lancashire County Council case, the Derbyshire case. Well, I can take this very briefly. It's volume 4 of the authorities at tab 47. It's 1994 All England Reports 165.
Sorry,
First,
give me the reference again.
1994 All England Reports 165.
Sorry,
The first instance decision, Mr. Justice
Volume 4,
Jowett,
47.
volume 4, tab 47.
And this is all in order to show what?
I'm sorry, my Lord.
This is to show what?
My Lord, the difference between guidance and direction. I can do this in minutes. It's a key case for the respondents. My Lord, the relevant section is on page 5 of the photocopy, which would be page 169 of the report. and it's section 13.6 of the Local Government Act 1992. So it's 5 paragraphs down on page 5. Section 13.6 empowers the Secretary of State to give directions to the Commission as to the exercise of its functions under section 13, including a power to direct that it shall, in the exercise of those functions, have regard to guidance given by him as to matters to be taken into account. And His Lordship, at page 173 of the report, page 9 of the photocopy, just above the bottom 3 paragraphs. Well, this is the passage. There's a paragraph beginning, it is accepted though, and then at the end of that paragraph, the concept of guidance goes beyond simply providing a checklist of factors which the Commission should take into account. To guide someone is to lead, to steer, or point someone in a particular direction. Well, I can stop there. We say that a direction must, it is submitted, be stronger than, although it may include, steering, leading, or pointing in a particular direction. Lord, the other main authority relied on by the respondents, and indeed central to the reasoning of the Court of Appeal, was Laker Airways, volume 2, tab 24. Lord, we have reproduced Laker Airways in the Queen's Bench report. The submissions are in, by the respondents, I think also in the Court of Appeal, are in the All England reports, so I'll try and give you the cross-references. The important passage in the Queen's Bench report is at page 699. Well, I'm assuming this is fairly familiar territory to your lordships, and I won't spend too much time on it. Page 699 of the Queen's Bench report, and in the All England report, it's at page 187. There are various headings in the judgment of the Lord of the Master of the Rolls: guidance, directions, directions versus guidance, and it's really the passage directions versus guidance. And Lord, it may help us all to understand, and I should have pointed this out to my other friend, to Mr. Batts, and I apologise. In his printed case, at various, indeed at all the levels when it's been presented to court, the passage is in paragraph 49 of Mr. Batts's printed case, and somehow something has gone wrong. Paragraph 49 of the printed case for the first respondent. Your Lordship will see that there are some underlined words in Mr. Batts's extract from Lord Denning's judgment in paragraph 49 under the heading Directions versus Guidance. And what's happened, probably by the miracle of Microsoft Word, or Microsoft Works, which is a contradiction in terms, you will see the underlined passage, it can only be used so as to explain, amplify and supplement them. And your Lordships will see when we go to the judgment that that has jumped from about 6 lines up, because the them refers to general objectives or provisions. Well, could I show you the original passage at 699, so you're not then distracted by that. Lord Denning, 699, directions versus guidance, bearing in mind, my Lord, that in that case the directions was a particularly strong version of directions because of national security. The word direction is in stark contrast with the word guidance. It denotes an order or command which must be obeyed even though it may be contrary to the general objectives and provisions of the statute. But the word guidance in section 3 does not denote an order or command. It cannot be used so as to reverse or contradict the general objectives or provisions of the statute. It can only be used so as to explain, amplify, or supplement them. So, and the them is, as you can see, a reference to the general objectives or provisions of the statute. So long as the guidance given by the Secretary of State keeps within the due bounds of guidance, the authority is under duty to follow his guidance. But whilst I'm with the passage, could I take it to the end? Because, with great respect to his lordship, I think he may have erred in what follows. So long as the guidance, and I submit, so long as the guidance given by the Secretary of State keeps within the due bounds, even so the authority is allowed some degree of flexibility. It is to perform the function in such a manner as it considers is in accordance with the guidance. So while it is obliged to follow the guidance, the manner of doing so is for the authority itself. Of course, that's right. But if the Secretary of State goes beyond the powers of guidance, he exceeds his powers, and the authority is under no obligation to obey him. It's the last few lines, which is an interesting sentence, not picked up by Lord Justice Roscoe.
So what's wrong with it? I mean,
Well, it's issue 2.
It's issue 2.
And either Lord Denning has encapsulated it in 10 words, or Smith and Eastello, and all that goes beyond it is
I see. I mean, your quarrel with that is
just the last few words.
Hoffman-LaRoche point.
Yep. Well, that's all I wanted to extract from that case. So guidance, in contrast with a direction, is there to explain, amplify, or supplement the objectives. And, my Lord, again, we say that a direction must be able to do all of this and possibly more. And without taking you to it, can I give you the other reference, which is a footnote in our written submissions, and that's Mr. Justice Sedley, as he then was in the case of Rixon, which is volume 4, tab 43, at page 6 of the photocopy, and Mr. Justice Sedley is there showing the difference. Volume 4, tab 43, page 6 of the copy, Mr. Justice Sedley pointing up the difference between directions and guidance in the Local Authority Social Services Act, or LASSA, as it is affectionately known. Make sure I've got the right page. It's tab 43, page 6, yes.
London Borough of Islington X, is that one?
That's the one, yes. Well, it's a passage which has been followed in several other cases, and it's at the top of page 6. You'll see that Your Lordship will see he's dealing with section 7.1 of the Local Authority Social Services Act. And what happened, there was an amendment. Section 7.1, local authorities shall, in the exercise of their social services, include the exercise of any discretion conferred by any relevant enactment, act under the general guidance of the Secretary of State. By an amendment introduced, Section 7A requires local authorities to exercise their social services functions in accordance with any such directions as may be given to them by the Secretary of State. What is the meaning and effect of the obligation to act under the general guidance of the Secretary of State? Clearly, guidance is less than direction, and the word general emphasises the non-prescriptive nature of what is envisaged. And then he picks up the submissions going back to Laker Airways. And the conclusion is that your liberty to deviate where you have good grounds. Lord, that was picked up by the House of Lords in a case we haven't troubled you with called Munjaz. Lord, if your Lordship's... Sorry, Lord. Guidance must be...
Yes, I remember we picked it up in Munjaz.
Yes,
right.
there was the Mental Health Code under Section 118 of the Mental Health Act 1994.
Was the contrast there with direction? No.
No, it was a guidance.
Pure guidance.
Is to follow, and your Lordships concluded that a hospital should follow the guidance in the Code of Practice unless there was good reason not to, which is the Rixon approach. Lord, if your Lordships accept that the directions fell within the rubric general nature as to policy to be followed, so that's the first stage, then the next step in the reasoning is whether or not it frustrated the purpose of the Act, which is the Padfield case, or was otherwise unlawful, because it prevented the OUR from exercising its powers, discretions under 29.4 or section 32 or 46.2. I think those are the three candidate sections.
They've abandoned the section 4 of the earlier act.
No, no, my lord, they haven't, but I'm saying under the 2000 Act, it's those three sections. Lord, the Court of Appeal also said section 4 of the earlier Act, and Lord, I hope carried that through section 11 to the other Act. But even so, even if it was that one as well, it would be a power. Section 6 contemplates an effect, performance of its functions under the Act. Therefore, my lord, the legislator, the draftsman, must have contemplated an effect or affect on performance. Well, one could just follow this through in a brief submission. The direction is focusing on powers of intervention rather than any duty to intervene, bearing in mind that the competition body is there in the background. So there are no duties being identified. And prior to the issue of the direction, the OUR had not intervened so as to set a cap in this area. So it had not exercised its discretion. Market forces were determining what should apply. And the question, the forensic question is, was the OUR acting in breach of its functions by not setting such rates and not intervening? Obvious answer, of course, no, because this was a power. So the next stage is, could the office, as a matter of policy, bearing in mind the objectives of the Act, decide not to set such rates or charges in the mobile market, and decide as a matter of policy not to set such rates for a period of time or until circumstances change and you can put in your own variables? Again, the answer is yes, on standard public law grounds. It follows, we say, that the minister is not frustrating the purpose of the Act if he directs under section 6 the policy, general nature of the policy, to be followed by the office. Because he's really doing that which the office could itself lawfully have done. And Lord, we submit it can't be contrary to the purpose of the Act if the direction effectively instructs the office to hold back in relation to this sector, while the question of market forces plays out, bearing in mind that the Fair Competition Act and the reference to the Fair Competition Commission is there at all times in case there's abuse.
When you talk about market forces, what do you mean?
My Lord, it's a crude shorthand for allowing the market to set the rates, so that if a new body comes onto any market, the best example in the United Kingdom would be the emergence of Sky Television and the ability to offer its, it has a set-top box which allows daughter A, B and C, in your lordship's case, yes. In my case, yes. Daughter A, B and all her friends to come and watch at any time, day or night, anything that they have thought is remotely interesting.
Well, that's market competition by producing a better product or product
no,
that
that's
doesn't
the prelude,
match what's there.
That's the prelude to Virgin coming along with its interactive box, yeah, which has most of the bells and whistles, but offers either access to a different set of channels, sports or whatever, or offers a better price. But and what's happening in... I'm sorry.
This case is all about the market effect of price, isn't it?
Yes.
That's what it's all about. It's not about anything else. So far as market forces are concerned, the office says we want to cap charges. The minister says, and on your argument, as a matter of policy, I think that's a bad idea. Now, I'd suggest to you, he's not saying, I think that's a bad idea because it's going to interfere with the price effect, the price market effect. I would suggest that this is an area where, so far as price goes, the market is not very efficient, so that there is room for competitors to come in with their mobile phones to Jamaica and to market them, albeit that the cost to the user who connects with their mobile phone may be a bit higher. And the minister thinks it's a very good idea. They should get established.
Yes.
That's really what it's all about. It's not about the minister saying it's very important to leave this to the market force of price.
My Lord, then I'm sorry, I'm only half answering your Lordship's
Yes.
question. Because your Lordship's introduction is exactly what the Minister was saying.
I'm basically sympathetic to the argument that the minister is motivated by policy.
Yes.
The question mark I'm saying is the nature of the policy.
My Lord, then I had failed to respond properly to the question. The Minister I can't change his explanation. He's put it in his recitals and in his affidavit. What he's saying is, during this early stage in liberalisation, let the market force, as I was using as the phrase, let it settle down, but also allow those who are new to the market to get a decent return on their investment so that they can stay in the market and use the income to improve their position by then being able to advertise, being able to offer special deals, etc. So that over a period of time, particularly when you've got full liberalisation coming in 2 years, you will then have set the scene for a vibrant, competitive market. Now, I've used that as market forces, but what the Minister is saying is let the market, when it comes to price, rates or charges, let them sort themselves out. And I will come back effectively with another direction if it's not working. And you saw that with the direction in 2004. That was almost an emergency.
So let the market rule, even if initially it's going to be more expensive, because in the long term it's going to be cheaper.
Yes.
So it may be bad for me today, but it'd be good for you tomorrow.
Yes, and it's my view of the public interest. Yeah, I mean, Lord, there are lots of ways of putting it, but I've used market forces. I daren't turn round and see what the wise monkeys say. But I thought market forces were a phrase that would cover all of these issues. But, my Lord, I don't seek to change or put a spin on any of the words used by the Minister. But, Lord, what he's summarising, he's telling his regulator, or the regulator over whom he has some power through Section 6, to use their powers or refrain from using some powers so as to promote competition, if necessary, by backing off on fixing prices, which may be low, fixed low, but may kill the market.
I think I've focused on the scenario. If we're looking at competitors who are marketing their mobile phones and their systems in Jamaica,
Yes.
I'm not sure that I've focused on the position so far as international calls are concerned.
Lord, can I come to that
Yes.
a bit later? But
Yes, that's right.
No, well,
If we haven't got there, that's fine.
It's also part of it, because at this time, before liberalisation, Cable and Wireless is the only person with the satellite, or the working satellite.
Yes.
So the contractual relationship between Cable and Wireless or whoever all the other mobile providers are in the market, there has to be a way of ensuring that the return on investment the mobile market gets is sufficient for it to continue to want to be involved, to extend different services, price competition, all the other aspects. And that's why 2.8 is the one that has such an impact. It's described in submissions that it wasn't just a question of Digicel losing out. It was a question of Digicel losing out and that which it should have been getting now being retained by its main competitor. So important stuff in an emerging market. Well, I've said enough on that unless I can assist further. Well, could I deal with one issue that arises in particular, and this is raised only, I think, by Cable and Wireless, in paragraph 11 of their case, saying that prohibition is not allowed when it comes to a section 6 direction. Well, they rely on two cases, Virgo and Tar. Lord, I won't take you to them because of shortage of time, but say to give you the references where they are. Virgo is volume 3, tab 31. Tar is volume 5, tab 53. Lord, the extracts from Virgo are in Tar. What they're looking at is regulation, the power to regulate, and saying if there is a common...
Give me the paragraph number.
Yes, Lord. It's paragraph 11 of Cable and Wireless's printed case.
Footnote 14.
Footnote 14. Well, maybe if I just show you Tar. Volume 5, tab 53. Lord, Tar has within it the extracts from the earlier case of Virgo. And at page 264 of the judgment, what was happening here in summary is that a regulatory power was being exercised. Indeed, it was the court's power, and it was whether or not a power to regulate the use of a matrimonial home could wholly prohibit a spouse from exercising his or her common law right to occupy, or contractual right. And the answer was no. If you have an ability or power to regulate, you don't extinguish by prohibiting. In Virgo, it was the power, the common law right to trade. So that itself couldn't be prohibited. And it's at page 264 of Tar, House of Lords.
Sorry, what's the common law right in Tar?
It's
right to...
it's the right to occupy property. It's picked up by Lord Pearson in his speech below C.
I mean, oughtn't we just to notice what the actual power is?
Yes, ma'am. You find it on the beginning of Viscount Dillon's speech on page 261. It's section 7 of the Matrimonial Homes Act. And you'll see it's set out at C, by section 7 of the Matrimonial Homes Act 1967, the court is given power where a spouse is entitled to occupy a dwelling house by virtue of a tenancy to which the Rent Act applies, etc., to order that the spouse, estate or interest in the dwelling house shall be transferred to his or her former spouse, or if there is a statutory tenancy, that the former spouse should be deemed to be statutory tenant. And section 7 is then 7.7, declares that the court's power to do so under section 7 is in addition to the powers conferred by sections 1 and 2. If, under section 1.2, the property-owning spouse could be deprived of his right to occupy the premises, it would not be necessary to provide this additional power. And the fact that it is given lends, in my view, further support to the conclusion that section 1.2, which I'll show you in a moment, does not give power to prohibit the exercise by the property-owning spouse of his or her right to occupy.
That power's on page 254, note 1.
Thank you very much, my lord. So those are the powers that were under consideration. At the foot of the page on 254, the court...
254?
254, footnote 1, my lord, is section 1.2 of the same statute. And it's the words regulating the exercise of either spouse of the right to occupy the dwelling house. And the House of Lords said, in summary, it's a very drastic inroad into the common law right of the property-owning spouse, if that means prohibit.
It seems to include the right to terminate the right.
Yes, that's the earlier part of the section. Yes. They focused on regulation. It's developed in detail at pages 266 through to 268.
It's all a question of construction of the statute.
Yes, ma'am. Every time. Because that's why I wanted to show you just one other authority to say that. Lord, it isn't terribly helpful, our submission goes, to look at Virgo, which is set out in extensive quotations at page 266 and following by Lord Pearson, or tar and tar, when what you are considering is a completely separate kind of a statutory provision, where here you're dealing with a regulatory regime, and it's the construction of a statutory power for the minister to issue directions that impact on the performance of functions. And the case that tells us that, my Lord, is called ING, NG, Enterprises. This is not in your Lordship's bundle. It's the only new case we want to introduce. Lord, it should be available in a very thin binder.
Is it referred to in your written argument?
No, my Lord, it's in response to the reply. It came a few days ago, my Lord. It might be freestanding.
Oh, I see.
Lord, it's our supplementary bundle of authorities.
Oh, I see. Yes, actually, what I meant was you make reference to the case in your...
But not this one, because...
No, I see.
Yeah, this is in reply.
Yeah.
And it's ING Enterprises, 1997, appeal cases 168. This committee recorded but did not resolve a submission. But there is a holding, my Lord. All I need to point you to is pages 176 to 177. And the submission there being made, this is a regulation of ice cream traders under the Hawker Urban Council bylaws, that if you had a power to regulate, you couldn't stop them trading. And the House of Lords, perhaps unsurprisingly, said it all depends on the statutory language.
Or even the Privy Council.
Even the Privy Council, my Lord. Page 175, at D, you'll see the references to Virgo.
So the oral stories wants to stick to the particular statute, construed in its context, and having regard to the statutory purpose, and not worry about too many other decisions on other statutes in different contexts. Is that the...
But, Lord, it may help if I, instead of merely agreeing with the Lordship, gave you the exact words of the judgment. On page 177b, the Lordships accept that as a general rule, a power to regulate an activity prima facie does not give the donee the power to prohibit the activity totally. Prohibition of an activity in part in a particular case or in a particular way may, however, as the cases show, be needed for effective regulation. The extent to which such partial prohibition is permissible depends on the terms of the power to regulate, etc. Our submission, Lord, is we're not in this territory at all. We're into a statute which is a self-contained statute which allows the minister to issue directions to the regulator.
It's really the regulation of a regulator.
Exactly so. Exactly so.
Is it said that the directive interferes with any of the duties as opposed to the powers of the office?
It said that the overriding duty to regulate in section 4 of the Office of Utilities Regulation Act is affected because of the words in section 4.1, the office shall regulate telecommunications.
Sorry, where are we looking for?
4.1, subject to the provisions of this Act, the functions of the office shall be to regulate the provision. That's 4.1 of the Office of Utilities Regulations. And that's it, I think.
That's the only positive duty is said to be...
Apart from 46.2. 46.2 of the Telecommunications Act the office shall make rules providing for the imposition, monitoring and enforcement of price caps. The rest are powers, but that rule, that obligation doesn't tell you as to the content of the exercise of the obligation.
But there are no specific duties which it is said, the direction is said to be
I don't think so.
inconsistent. Because the position might be different then, mightn't it, on the true construction of Section
It might be
6.
more problematic. It depends on the interrelationship. The candidates have usually been 29(4), 32 or 33, and Section 46. Lord,
Sorry, just pause on
sorry.
that. I'm not quite sure why it would be more difficult. I mean, Section 6, the policy to be followed by the office in the performance of its functions. Functions means
powers and duties.
powers and duties, but I suppose
It might
can you be required to follow the policy of not performing a duty? I mean,
well,
That itself would be a question of construction of the statute.
yes,
according to Section 6, the answer is yes, possibly, because you shall give effect to the direction.
that begs the question as whether, I thought we were on to the question now, whether the direction is a good one, whether
Yeah,
it...
yeah. No, my Lord, I'm focusing only on Padfield and similar arguments. My Lord, could I leave Padfield, subject again to judicial enthusiasm for more submissions, and move to one criticism of the decision? And this has been repeated picked up by the Court of Appeal, accepted by the Court of Appeal. It's a good point, picked up by both respondents. And it is said that it was unlawful for the minister to advance or prefer one aspect of policy.
Sorry,
Unlawful for the minister to refer only to competition. And he should have ticked all the boxes of Section 3 and gone through a balancing exercise. Indeed, it said this was a disproportionate process in giving undue weight to advancing the cause of competition. But with the greatest of respect, my Lord, it's a brief answer, that cannot be right. The minister has the ability to make his own decisions as to what is in the public interest, and he doesn't have to go through parrot fashion all the objectives of the statute and give one 10 points and the other 15 points, and some of them 0. Indeed, that is good law from many cases, including Corner House. Lord Bingham is in our footnotes in the introductory paragraphs, paragraph 40. What is a relevant consideration? The weight to be given to relevant considerations is for the minister. Would we address this, to save me making any more submissions, in paragraphs 36 to 41 of our printed case? And your Lordship will see it is the Court of Appeal that uses the word disproportionately as paragraph 36. And 36, the Court of Appeal, it is submitted, erred when it substituted its own view of the relative importance of the various methods by which the minister could accomplish this protection, as indicated by the learned President when he stated, and the record references in footnote 13, I agree with counsel for the appellant, which is then the OUR, that the recitals to the direction make no mention whatsoever of the statutory objects such as fair competition, protection of customers, and encouraging economically efficient services. The recitals clearly demonstrate the minister's determination to elevate competition simpliciter disproportionately to the exclusion of other objects of the Act. As we say in paragraph 17, with greatest respect to the learned President, that is a misunderstanding of very important public law principles, that this was a matter for the minister to decide and could not be described as irrational. And my Lord, we then on paragraph 40 refer your lordships to the judicial review judge, where we say that the judge gets it right in paragraphs 40 and should be preferred to the Court of Appeal. Lord, for all those reasons, we say the direction was not flawed. It fell within the ambit of Section 6. It was not Padfield bad, and in all other ways it was lawful. It follows that the OUR, by express provision in the statute, is obliged to give effect to the direction. So the next issue, again subject to any questions on issue 1, is issue 2, which I can take extremely...
If you win issue 1, you don't need 2.
Correct.
But vice versa.
Yes, issue 2 is the nearest to a point of academic interest. This is now 7 years later. But it raises a point of general public importance as to whether or not a regulator, when served with a direction such as the direction at issue in this case, can simply ignore it or take advice and simply ignore it. Or must the regulator do what we can say is the proper thing, subject to 2 lines of Lord Denning's judgment in Laker Airways, and that is go to court, because it would be, as we say in paragraph 44, a recipe for regulatory chaos if the regulator is here and simply ignores, and lawfully simply ignore a direction from a minister at least purporting to be made under Section 6 of the Act, on the basis that the regulator is advised it is unlawful. Lord, without taking you through the submissions, could I just give your lordship a couple of references?
Can I just, well, yeah. I mean, we did have a case in the Privy Council a couple of years ago where, I can't remember which Caribbean island had brought in a new race relations law, and there'd been then a change of government, and they decided it was invalid, and they simply ignored it. And our judgment certainly said something about how they might perhaps best have dealt with that.
I'll try and find it. Those behind me are writing down. Well, I can take this, as I say, very quickly as a series of propositions. In our paragraph 44, where we refer to Smith and East Ello, in the footnote, Lord, at paragraph 17, is the textbook reference. I won't take you to them, I'll tell you where they are. Smith and Ello is volume 5, tab 52. Hoffman La Roche, they're all being alphabetical, volume 2, tab 19. But the summary is, we say, well set out in Wade and Forsyth, volume 5, tab 66, and in De Smith, volume 5, tab 62, and also in Datafin, which we have at the top of page 19, volume 4, tab 46. Lord, I don't propose to take you any more, just to say this, that the problem with the approach of the Court of Appeal, and indeed the approach of the respondents, is they have picked up on the case of Boddington, and that goes back to Bug, and all those other cases which were developed to ensure that a disadvantaged individual would not be prevented from raising as a defence a collateral challenge. So what this regulator has persuaded the Court of Appeal to accept, and seeks to persuade your lordships to accept, is that they can ignore a direction, wait to be sued, as they were in judicial review terms by Digicel, and then in defence say this is a Boddington case, we can raise as a collateral challenge the lawfulness of the direction, we win. as I say in paragraph 44, that is a very odd position for a public body to take when faced with a direction which is not invalid on its face, and there are debates which we're having as to whether it is too wide or too narrow, but the proper course is for the body to obey that which is directed to do. If it doesn't want to obey it, to go to court where it may or may not be quashed by a court of competent jurisdiction. That becomes even more important when passage of time, as in this case, because when it comes to relief, the intervening years may be of some importance and may affect the exercise of discretion. But unless I can assist you further, I didn't want to say more on issue 2. Lord, issues...
I'm just thinking where the ramifications end up, because here a direction given to the regulator, don't regulate. In violation of the direction, the regulator regulates. And how about the regulated person? Is the regulated person bound to comply with the regulation in any event, whether you're right or wrong on the regulator's duty?
Or the regulator then takes and says at an early stage, this is to be determined by the courts. All we're saying in this fairly brief point is there is now ample authority over the years to say that a direction, an order such as this, is presumed valid until struck down by a court of competent jurisdiction. That's one argument. There's the 2 lines of Lord Dennis.
Is that true of the regulated? If you're the regulated and the regulator makes a regulation which is ultra vires the regulator, has the regulated got to obey it nevertheless? So can he say, I'm not going to do it, I'll wait until I'm prosecuted, then I'll say there was no this...
Well, he can take the point because so he falls within the Boddington bug quietly in the set of cases, because he's the citizen that, by way of defence, can...
If you're already the regulator, not the citizen, you're in a different position.
Yes, yeah. Well, that's, my lord, that's the point. It's otherwise what you're doing is you're compelling the potentially regulated or non-regulated party to go to court, drag you to court, so you can defend yourself. Well, it's a short submission, you either like it or you don't. I don't need it to win the case, fortunately.
Well, you might. If you lose on the first issue, this is your fallback.
Yes, Lord. I'm sorry. I'm hoping to win on the first.
Hope springs eternal, we all know that.
Yes, my Lord. But that...
yes.
Well, I wasn't going to say anything more. I'll come back on reply if necessary.
Yes.
My Lord, what I did want to do then is deal at even greater speed with issues 3 and 4. Sorry. What is now, I've slotted into 4, which is the Interpretation Act issue. Could I call it 5?
Right.
The issue raised by Cable and Wireless, and now by the Office. Well, the third issue is whether or not these paragraphs do offend the direction. And I'm in some difficulty at this point, my Lord, because normally one turns to the regulator to see what is the argument I have to meet. And the regulator is eloquently silent on issue 3. And, Lord, it might make my submissions a lot shorter if I take them at speed and then leave the reply to Cable and Wireless to see what they have to say. But it would help, certainly, the presentation if the regulator accepts or doesn't that determinations 2.6 and 2.8 were in breach of the direction. It would make life much easier.
Well, certainly his written argument, I noticed, is conspicuously silent. It moves from issue 2 straight to issue 4.
Well, I'm assuming that the regulator agrees with us on issue 3. It was certainly the intention to act contrary to the direction. That's what the battle was about. That's what the row was about in 2002. It's Cable and Wireless who persuaded the Court of Appeal that the determination only has impact on the fixed line operator, which is a fundamental misunderstanding. But I'd really quite like to know where the regulator stands And if the regulator is adopting cable and wireless, that's one thing. But a public body coming to the Privy Council, we submit, should have a position on its own determination. So I don't hear Mr. Batts rising to his feet, so can I just take this quickly?
You want me to say something?
It's an invitation there, Mr. Batts. Are you taking this point?
It please my lord. This silence is deliberate. We are a regulator and we didn't wish to, in effect, interpret our own decision and would prefer, and did so before the Court of Appeal, to allow the court to determine that issue, because it was a decision we made after consultation. It's there in black and white with the reasons. We felt if we weighed in on one side or the other and said, oh, this is the effect of it, then we may have been weighing into the battle. But your lordships clearly wish me to state the position of the OUR, and I shall do so candidly. The fact, my lord, is that the OUR intended by this determination to regulate the charges for fixed mobile interconnection. The route they did it was to cap the amount that Cable and Wireless was entitled to collect from its own customer. The effect of that, therefore, its own fixed line customer, I should say, the natural effect of that, and the one we clearly foresaw, was that Digicel would thereby naturally not be able to raise its charges above the cap unless Digicel was prepared to throw the additional amount on its own customer. And that would not foreseeably happen. So, to put it in a nutshell, technically, it may be true that on a strict reading of it, it did not breach the direction, but it was the intention of the regulator to breach direction because we knew the effect of the determination would be to cap the amount that Digicel could charge, or would charge for fixed mobile interconnection, unless Digicel or any other mobile competitor was prepared to throw the additional amount onto its own customer. I hope I please you.
Well, Mr. Fleming, I would have thought that's good enough for you, isn't it? Because if the intent was to bring about the very effect that the minister was anxious to avoid, whether technically it was or was not contrary to his direction.
It must be common ground between even the operators that the indirect effect involved a movement of money from Digicel to Cable and Wireless, or a diminution in the amount of money that Digicel could receive, and therefore 2.6 and 2.8 did have the effect of contravening the direction. Well, could I leave that to submissions in reply, unless your Lordship does require some explanation. My Lord, we say in a nutshell that the submissions made by Cable and Wireless to the contrary are unreal in terms of examining the consequence. And this is demonstrated by perhaps only one sentence in one paragraph. This is in paragraph 50 of the printed case for Cable and Wireless.
50?
50, my Lord. Well, we have comments, if necessary, on every single paragraph dealing with this issue. Paragraph 50, you will see what the second sentence, what the OUR capped was the amounts the CWJ was required to pay Digicel. So, accepting even in that sentence that what is being capped is the money moving towards Digicel. But that's said not to breach the direction. Then at the top of page 23, you have the sentence that could only be written on behalf of an incumbent monopolist. Digicel could have refused to interconnect with Cable and Wireless Jamaica. Well, that is, as I said, unreal. Cable and Wireless then had a complete monopoly on the fixed line phone services. It could not fail to interconnect. but also that there was an interconnection agreement, and even more, there was a Section 29 obligation that your lordships have seen, requiring interconnection and imposing an any-to-any connectivity. And, Lord, the same unreality goes on into paragraph 51 and beyond, when it said that the price cap has nothing to do with the mobile market. Lord, in light of what my learned friend Mr. Batts has said, it was intended to, and indeed had a very serious impact on Digicel. I mentioned earlier some figures, Lord. This is now between providers. It's common ground between the providers because orders have been made and monies have exchanged. But as a result of the challenge, and I'm looking now only at 2.8, which is the international cause, the effect of success before the first instance judge was that Cable and Wireless was ordered to pay the shortfall, which Digicel had been deprived of, plus interest. And as I was trying to remember the figures on my feet, it was $2.07 million US dollars. When the Court of Appeal overturned the decision, Digicel had to repay a similar sum, which was by then approximately 5.4 million.
Where do we pick up these figures?
Well, these are figures that I'm instructed were the effect of the agreed orders. And as this is now...
Are they in writing before us?
They're not. They're in an order of the court, but the order just says repay. I'm just giving you the figures. Lord, I wasn't...
Sorry, can you just...
Yes, I'm...
So, Judge says
when the first instance judge upheld the challenge by Digicel, the effect was to order Cable and Wireless to make payment to Digicel.
Yeah.
That was 182 million Jamaican dollars, which translates into approximately 2.07 million US dollars. That's 2003. 4 years later, when the Court of Appeal reversed that decision, there was a repayment, but this was now attracting interest and some further payments, and it was 5.4 million US dollars.
Okay.
So there was a very serious impact on the mobile market.
But the difference between the 2.07 and the 5.4 million is just the rates of interest.
I understand, sir. Yes, that's
So
what
that's been paid.
yes, the interest,
Has been paid.
it has been paid, yes. Well, I'll clarify those figures. It was merely a shorthand to illustrate that there was a direct impact. Could I turn really now at speed to the fifth issue? This is the new issue, the Interpretation Act. The reason we objected to it being argued before your lordship is that it was first raised in the course of the agreeing the statement of facts and issues this year. It's not an issue that was raised at any time during the litigation. However, it may be that the new rules for the Privy Council, Rule 25.1, means that my objection is worthless because there is a right to raise points. I'm not fully conversant with your lordship's new rules, but 25.1 may require just...
Well, whatever point you like.
Sounds unlikely.
Well, whatever point you like, you can raise.
yes, apparently.
Well, when you say a right, I mean, what, a indefeasible God-given right? I mean,
I think so. This is what it says.
I mean, there's quite a lot of literature that we like to hear what the local courts have to say.
Well, this is what it says.
New rule, what does it say?
25.1, a respondent who wishes to argue that the order appealed from should be upheld on grounds different from those relied on by the court below must state that clearly in the respondent's written case, but need not cross-appeal. Now, it may be that that means on the grounds argued below, but it doesn't say so, and I wouldn't want to interpret your lordship's rules. But
I would certainly want to interpret them in a way that doesn't rid us of our discretion.
We
must
have a discretion.
I hope your lordships have, because I object on behalf of Digicel to spending time arguing this point, because, for several reasons. One is the minister, as your lordships know, has stepped out of the appeal process. The government of Jamaica is not here. This is an issue that goes fundamentally to every direction, every order, every regulation that is published, is not published, is produced under various regimes in Jamaica, is of very great importance indeed, because the argument by my learned friends, both of them, the office as well as Cable and Wireless, is that the direction is invalid because it was not published in the Gazette in 2002. And we say that's a point that's been raised far too late to be entertained.
When the minister withdrew or expressed no interest in this appeal, did he know that all his regulations, or indeed
No, this was, as far as I'm aware, was raised in the process of agreeing the agreed statement of facts and issues, and is either after or at about the same time as the minister's withdrawal of his appeal. So it's new. Well, that said, it's an interesting point, and I'm very happy to answer it and can do it in a minute. Could I show you one point and then...
Well, the usual Day-Bini essay, do it in a minute.
It's the minute just to show you the section. You've now seen the legislation. Lord, the Interpretation Act is in volume...
It's in the separate...
No, volume 2.
Volume is... Oh, you are... No, sorry.
Well, I've got so many volumes out.
Interpretation Act, yes, volume 2.
2 or 3 of them.
2 or 21, I think.
21, volume 2, Lord.
221.
And all one has to look at is this with an eye to section 6 and section 10 of the Telecommunications Act. Section 31 is what we're concerned with. Indeed, it should start at section 29, which is page 21 of tab 21. And this is provisions as to the making of regulations. Regulations are defined in section 3 as including, this is page 10, rules, bylaws, proclamations, orders, schemes, notifications, directions, notices and forms. So, what is said against us is there is a draftsman extending the word regulations to include directions. Section 6 of the Telecommunications Act has a reference to directions, but look at 31. All regulations, which now includes directions, all regulations made under any act or other lawful authority and having legislative effect shall be published in the Gazette, and unless it be otherwise provided, those words as well, shall take effect and come into operation as law on the date of such publication. Well, the submission in a nutshell is that this direction obviously does not have legislative effect. It is either administrative or executive.
not least because it's secret, isn't it? Yeah.
Well, it's the communication of policy, but there's more. Section 10 has the same language. Could I just show you section 10, because this is where this section is going. Section 10 of the Telecommunications Act, that's a separate bundle. If my other friends write, they're right on section 10 as well. And section 10, with greatest respect, shows the absurdity of this submission. Section 10 of the Telecommunications Act. The Minister shall, by a direction in writing to the office, so it's 1-to-1, Minister to office, require the office to invite applications for the grant of a carrier or service provider, or both, and such direction shall specify. And then 2, upon receipt of a direction, the office shall publish. But according to my learned friends, no. This is a direction in writing. It's even stronger, we are told, than section 6, and it must therefore be legislation. Here's the argument. But the absurdity of that is section 10.2 tells you it has effect upon receipt. So that also kills the section 31 argument, and for another 20 reasons, it's not a good argument. Well, could I leave that to reply as well? And subject to judicial interest, those are our submissions.
Yes, thank you very much. Mr. Beswick.
follow. Just say no.
Is there anything you wish to say?
No, my lord.
No, thank you very much. Mr. Batts, would you like to bat for 10 minutes?
Very well, my lord.
Just lift it up. It comes across.
My lords, I propose to treat with issue 1, and my learned friend, Mr. Graham, will treat with the other issues currently before the court. I begin, my lord, by observing that, and perhaps it is a result of the nature of the material before us, my learned friend has trespassed into issue 4, which has been withdrawn, as well as into some of the matters which were before the Court of Appeal, but which were not raised in the case before your Lordship's board, and in particular, into the issue of the effect of the absence of rules. This is a matter that the Court of Appeal treated with and made a decision on, and which has not been challenged formally before your Lordship's board, because we were able to satisfy the Court of Appeal that the absence of rules does not prevent a regulator or a functionary from acting. And there are several authorities on that, which tomorrow I will refer to, my lords, because in fact, although the issue is not formally before your Lordship's board, it emerged clearly with
It will be the day after tomorrow if you wish us to be here.
Very well, my lords. Now, my lords, my learned friend in his case, I submit, has fallen into error, largely because of a confusion in his case of the concept of control and influence.
Control and what?
And influence. My lord will see that at paragraph 10 of his written case, he virtually rolls the two concepts into one and says that, and I'm paraphrasing, the Telecommunications Act involves the minister controlling and influencing the Office of Utilities Regulation, and that wherever the two interact, the OUR advises and the minister decides or directs. We submit that this is inaccurate. It is fundamental to this case to understand, I submit, that the Act, in fact, has two regimes. There are areas in which the minister controls. In particular, Part 3, licensing, and some of the others my friend looked at. But then, the bulk of the Act presents with areas under the control of the Office of Utilities Regulation. Those are areas in which the Act clearly we submit, and unambiguously, it is the regulator who shall consider and determine, for example, under 29, whether an interconnection agreement is satisfactory in that does it meet the objects of the Act? Does it satisfy the needs of the consumer? Does it reflect competition which is fair? Will it lead to efficiency in the industry? Section 32.
Section what?
32, my lord. Where the real, again, it is for the OUR to look at. And my friend says it's a power. It's not a power. The OUR has a duty to examine any real file by an existing provider or by a party who chooses to file a real. It is a duty to examine it and to satisfy itself that the statutory objectives are being met or are likely to be met or not, as the case may be. Having exercised its duty to examine, then the regulator now needs to exercise its power one way or the other. And the clearest example of all in the Act, my lords, Section 33, dealing with a situation where there's a dominant player. Nothing could be clearer. Parliament has said the professional, independent, expert regulator shall ensure that such a dominant provider has prices, which are cost reflective. And the Act, interestingly, in Section 33, although it uses the word guide, says that it should be guided by, lists the 5 measures to be applied to determine if the prices of the dominant provider are cost reflective. This is a duty. It is our submission, my lords, that Parliament did not intend, by Section 6, to empower the minister to substitute his discretion and to thereby exercise the duty imposed on the regulator to say, do not interfere, even where, having exercised your duty to examine this agreement or this real or this dominant provider's prices, and having formed a view that it is uncompetitive or unfair to the consumer or will lead to inefficiency in the market. Having done all of that, Parliament did not intend the minister to be able to say to the regulator, do not interfere with prices. What the minister is thereby doing, what Parliament would thereby be doing, is empowering the minister to, in effect, exercise the statutory duty, the statutory power, the function of the OUR, to remove its discretion or to exercise it on the OUR's behalf. And I will, my lord, hopefully demonstrate this by reference to the terms of Section 6 itself. Section 6, my lord. That's
Six,
it.
yes.
Section creating the power of the minister
Yes, thank you.
to issue a general direction. And also by reference to the very framework document which the minister put before the court in his affidavit, which demonstrates that the basis of creating the independent regulator was to have regulation of the market, to have an expert regulator which would, independent of politics, independent of pressures one way or the other, we know the dynamics of society, this independent regulator who would ensure that competition is fair, industry is efficient, and the consumer protected. And this was the basis of the legislation.
Right,
Section-
now, it is 4 o'clock. If that's a convenient moment, we will adjourn until
It is a convenient time, my lord.
10:30 on Thursday.
Very well, I'm much obliged. I don't know if I was to see this, but you left it on the podium.
That's the key to everything.
Well, I didn't read it. Give me back.